Get your favorite health tips right here on U24. Maintain your kidney by drinking 8 to 10 glasses of water each day. This can be in form of soup, tea, water, cooked grains, and boiled vegetables.
Hello, my name is Erica Murunchi and welcome to Be Inspired by Erica. So today I want to talk about personal hygiene. Personal hygiene is not just a habit, it is a way of life. By maintaining personal hygiene, you will reduce stress, improve on your focus, show respect for yourself and others around you, to the people around you. Take care of your space and your life. Keep your room tidy, wash your hands, cut your fingernails, comb your hair, brush your teeth, and many others. Take care of your space and your life. Brush your teeth, make your bed, bathe, cut your fingernails, comb your hair, and many others. Make cleanliness a habit. Personal hygiene should be a priority. Cleanliness is next to godliness. Stay blessed. Much love. Thanks for watching.
Hi, my name is Doreen Tuhidire, coming to you from Be Money Wiser, and we're going to be bringing to you the hashtag 100 Ways to Be Money Wiser by Mrs. T. Tilda Nabandra. We're going to be running this hashtag 100 Ways to Be Money Wiser on U24 Television. Don't miss out.
And welcome to the Checkpoint. This is U24 Television, the National Youth Development and Educational Channel. The Checkpoint comes to you every Tuesday 9 p.m. to 10 p.m. here on U24 Television. This evening, we are discussing an interesting topic which has made trends in the last few days. Contempt of court, behind the judicial powers in court proceedings. And this evening, I have an able panel with me. I will be introducing to you shortly, but you've seen what has been happening on X mainly. We've seen Ugandans raise money for Dr. Aspire Sentongo to meet the cost which had been slapped on him by court when he was found in contempt of a court order. But what is contempt of court and when does it bite? With me, starting from my far left, I have Jack Kateeba Musoke. He's a lawyer. You're welcome, Jack, to the Checkpoint.
Thank you, President John. Good evening to everyone. I'm happy to be here.
Next, I have Obed Nankunda. Obed Nankunda is also a lawyer. You're welcome, Obed.
Thank you, moderator, and to the entire nation. I'm happy to be here. Hope a message will be delivered.
And then I have Tulyazalwa Mark Mugisha. He's a lawyer, he's an advocate working with Arcadia Advocates, and he's a former contestant for Kira Municipality MP. You're welcome, Mark.
Thank you, Vianny. Good evening, viewers. I'm happy once again to be on this platform to yet discuss an important legal aspect that will benefit the other litigant or citizen watching out there.
Starting from there, Mark, you're going to start us off and take us through what is contempt of court.
Contempt of court is simply violation of a court order or acting in a manner that displeases the judicial officer presiding over court. Now, contempt is in two respects. We have the criminal contempt and the civil contempt. Referring to the criminal contempt, any Ugandan out there watching can easily remember the incident of Aaron Kiza when he was representing Dr. Kiza Besigye before the court martial. Because of his conduct while in court, he was found to be in contempt of court and sentenced and convicted and sent to prison, to Chitalia prison.
9 months.
For 9 months. The same incident affected our famous lawyer, Malema Birizi, when he was found to be, when his conduct of critiquing judicial officers, in particular Justice Musa Sekana, was found to be in contempt and sentenced for 18 months in prison. Now, that's criminal contempt, where your conduct against a judicial officer displeases him and he exercises his discretion to send you to prison. Then the civil contempt arises from civil proceedings. When you talk about the civil proceedings, it could be a dispute relating to contract, it could be a land dispute, it could be a matter of an administrative nature, and court has already pronounced itself on what needs to be done. In most cases, a person is found to be in contempt of court where court has already issued prohibitive or restrictive orders. In most cases, where court has issued an injunction, or where court in its final determination or ruling has issued an order, say a permanent injunction, prohibiting an individual from engaging in particular acts. Now, for civil contempt, for it at least we are lucky, it has a defined threshold, or it has a limit or ingredient that someone may base on to know that when I break A, B, C, D, I am in contempt of court.
I want to come to you on those ingredients
yes,
for contempt of court in civil and how they relate to criminal. But I want to come to Obed. He mentions the aspect of contempt of court, including conducting yourself in a manner that displeases the judge. How can one avoid displeasing the judge? Because judges are human beings. So, what is contempt of court in that regard? Isn't almost everybody at risk of being found in contempt?
Okay. Well, good evening, dear viewers, once again. I would want to maybe explain it further on the issue of displeasing. It is actually not necessarily displeasing the judge, but disrupting justice in court or court proceedings. It may not necessarily be in particular the judge, but as long as the act or the conduct, your conduct as a contemner is disrupting the court proceedings or the administration of justice, it may not necessarily, because when you talk about displeasing the judge, that means it is particularly the judge who has been interrupted or interfered with. Yet when we talk of contempt of court, the interruption is either in respect of the administration of justice or you are disrupting the court proceedings. For instance, like what our brother Aaron Kiza did, banging tables, shouting. You are not only shouting to the judge, but all the people who are in the courtroom are also being affected by your noise. So, and then you are disrupting the court proceedings. In other words, the person who is displeased is not only the judge, but everybody who is in the courtroom.
So can any other person in the courtroom charge you for contempt?
You cannot be charged, of course, by any other person apart from the judge, because, of course, in the courtroom, the person presiding over is the judge.
Absolutely.
Exactly.
So it is the judge displeased with your
whatever
actions.
he's doing is in the line of administration of justice. So when you talk of any manner or any conduct that displeases, that means even when you come dressed in a manner that does not please the judge, you will also be charged of contempt of court. It's not a conduct that displeases an individual, a judge, but rather the administration of justice.
Okay, thank you. Jack, I see you're shaking your head. Do you agree, or for you, are judicial officers indeed, when displeased, are they justified to go for contempt of court? What is it, in your opinion, contempt of court? That animal called the contempt of court.
Thank you, President. For us to understand the concept of contempt of court, we need to understand that this principle is based on two issues. Number one, disobedience, and number two is disorganization. Just like what my brother Obed was saying. But of recent, we have seen a shift from the core principles of disobedience and disorganization to now individuals, which is very, very wrong and very divergent from the history of this principle. Because when you look at the principle, how it started back in the 12th century in England, it was basically about the king. It was actually called contempt of the king.
The crown.
Then it went to contempt of justice. Then after revising it, after several case laws and common law precedents, then we understood that it's not supposed to be about the person. It's supposed to be about the entire administration of justice. But when you look at how things are happening in our country now, actually of recent, we have had so much of contempt of people are even wondering what is this, and now it takes us back to what Honorable here was saying, that for the civil side of contempt, it is very clear, but then when it comes to the criminal side, criminal contempt, that's where the discussion should be, especially in our country.
Let me bring in Mark on that, because he seemed to suggest that there are ingredients which bring to us what amounts to contempt of court. I wanted to give you a case study in 2020 when we were heading for 2021 elections. One Ivan Sebaduka, I think that is the right name of his, he challenged the Supreme Court. He had petitioned that those restrictions on COVID and what have you should be removed so that people are able to campaign. He intended to be a presidential candidate. And in his submissions in Supreme Court, he called the justices of the Supreme Court as a council of fools. And he was sentenced to 2 years. He served that sentence. What constitutes that contempt of court? What are those ingredients?
When we are talking about contempt of court and defining ingredients of contempt of court, we have to distinguish between the civil and the criminal contempt. One, before I forget, I must commend the Supreme Court in that trial of Sebaduka. Before they held him to be in contempt of court, they afforded him a fair hearing. If you closely followed, he even had an opportunity to make submissions to substantiate why he called them a council of fools, bearing a fact in mind that he's entitled to his opinion.
And in those submissions, again, he said, I repeat, you are
absolutely
a council of fools.
Now, that is completely different from what was done in the Aaron Kiza trial. They just said, okay, from your conduct, we are sentencing you to this period because of ABCD, without affording him an opportunity to be heard. What if the man had a period of insanity during that period? And we all know that a person is not criminally liable for actions done where he cannot control his mind, but you've not listened to him. But coming back to what constitutes contempt of court, in the criminal perspective, we do not have a threshold. We do not have ingredients established for contempt of court. And the reason is simple. The doctrine of the concept of doctrine, of the concept of a contempt of court originates from England. And now we all know, like it is here in Uganda, a Muganda will tell you, Kabaka teba mutunula mukamwa. What the king says is final. And now this concept applied in England. And now during the 12th century, when we have the contempt of the king, if you do an act that displeases the king, you're held to be in contempt. Now, once the economy started developing, as the world grew, we had it evolving. Now, during the reign of King Henry II, he extended it now to contempt of the temple of justice. That means now he extended it because now the king could not rule for himself. He appointed people who were administering justice on his behalf. Therefore, the appointees of the king, who can be now the catikiro in Uganda here, whatever they decided, you had to respect them because they were agents of the king. Now, the doctrine of concept extended from the king himself to his agents. Now, as we evolved, knowing that this now spread to all the Commonwealth countries, and in Uganda, we just simply did a copy and paste of what happens in England. Now, that's how we adopt the criminal perspective of contempt of court. That is why I was deliberate when I said conduct that displeases the judge. Because if in the eyes of the judge what you've done is not befitting, then you shall be held to be in contempt, which is completely different from the civil perspective, because we have the threshold that has been defined. The judge in the case of Erasmus Nsanjiranabo against Colonel Kakabagenda, when he was held to be in contempt of court.
Who was in contempt?
Colonel Kakabagenda was in contempt of court. And they defined the principles clearly.
What had he done?
You know, we are not safe in the country to discuss certain issues. Now, since it is a decided matter, the facts are on the internet and anyone can always access them. But allow me an opportunity to simply give you the guidelines on which court basis to find you to be in contempt. One, there should be a valid court order issued by a court of competent jurisdiction. So say, the courts we have here, it can either be a magistrate court, it can be the High Court, Court of Appeal, or the Supreme Court. Once they have issued an order, two, you must have knowledge of the order. Once you have knowledge of the order, you must be capable of complying with that order. If you are incapable of complying with the order, then you cannot be held to be in contempt. And then three, you deliberately violated the order. So when we have all the four in place and they have all been satisfied, that's when we can say you are in contempt of a court order. A case in point of the tweet scandal involving Dr. Jimmy Spire Sentongo. Court ordered him to refrain from further tweets that may affect or damage the reputation of the institution.
Pending the determination.
Now, that is a court order issued by a court of competent jurisdiction. Now, while the order is in place, he goes ahead to violate the order. He was aware of the order stopping him from his actions. Two, he was capable of refraining from further utterances on X. Three, he had knowledge of it deliberately. Now, he actually went on to continue with further utterances, which tarnish now the reputation of the university.
Thank you very much. We are streaming live on YouTube. You could search U24 Television and then be able to follow this conversation on YouTube, and then send us your comment on that YouTube as well. We shall be reading them in the course of this conversation. But also, we are present on X. You could search U24 Television or join Vianny Ayebare. Send us your comments and we'll be able to read those comments. U24 is also available on other social media handles, on TikTok, on Facebook, and all other social media platforms. And I want to go to Obed. He tells us that, for instance, Dr. Spire Sentongo was aware of a court order which had been passed by a competent court, and he proceeded to post Now, should anybody complain of the court actions? I'm coming to you, Obed. Or why have Ugandans rallied behind him and contributed the 30 million? The last time I checked this evening, it was about 36 million. Are Ugandans also in contempt of court? Why is it that Ugandans do not appreciate this?
Okay. I'm going to answer you, but I would still want to begin with the other point where you talked about to Mr. Sevaduka and the words he uttered. First of all, scandalizing the court. In the face of the court, he scandalized. First of all, it all begins with the sanctity of the court of the whole judiciary. That in the eyes of the public, the court or the judiciary or the judicial system has respect. And all orders issued by court are bound to be followed by all subjects of the law in Uganda. So any act that you do that intends to scandalize or intends to violate the authority of court can never go without being punished, because we have to protect the sanctity of court. Now, his words, by the face of what happened, they were already, it was an attack on the authority of the court, and that's why he has to go having been punished. Now, back to this other point, even basing on his very explanation, that for one to be held of civil contempt, there must be a court order, and that the contemptor must have knowledge about this court order. The contemptor must have deliberately violated the court order. The contemptor in respect of this matter is Mr. Spire, not the general public. Actually, the general public comes in to sympathize with him, because at the end of the day, even if court now slapped, a fine for having violated the court order, he had to pay, even if he had the money on his own. But of course, we are now considering that him and other relatives and friends, they are collecting money to help him, to save him out of this situation. And also, that also adds on the sanctity of court, that people are respecting the court. They are now in respect of the court, that whatever orders are issued by court, they are going to be followed. That if they had no confidence in the court, in the judiciary, they wouldn't have collected the money. But because they know the repercussion of him failing to pay the fine. You get my point? So we cannot hold the people who are collecting money as contemptors. We only have one person who violated the court order, and the court order was restraining him as an individual for the acts that he was doing on Twitter.
Someone would think that the fine is meant to punish the contemptor. What if the KIU brings this to the attention of court, that in fact this person has not felt the pain of paying the fine? Do you think the court would be dissatisfied that he has paid the fine by collecting it from the public?
What matters is that the fine imposed by court has been fulfilled, no matter where the fine has come from. First of all, it deters other people who would also want to do the same. Much as it is being imposed on one person, the contemptor, but the public is also looking at what is happening. So, and actually people are learning that when you violate a court order, there are consequences.
So in fact...
But my question would be, what image or what message does it send back to the judiciary? Does it mean that all the rest of us do not appreciate the mistake he committed?
Let me take that question to Jack. Is there a message being sent by the judiciary? And I want you to look at this in the entirety of the examples we have. Currently, Isaac Semakade, the president of Uganda Royal Society, is in exile because of contempt of court. He was sentenced for being in contempt of court. Aaron Chiza, as we said, he had been sentenced by the military court martial last year in 2025. But also, right now, there are proceedings. I think the DPP has filed an application against Aaron Chiza for publishing information in regard to the ongoing Dr. Kizza Besigye case, urging that he should be sent to prison for being in contempt of court. And then we have this contempt of court Malema Birizi has previously served the same, and then we have this Dr. Spire Sentongo issue. In general, is the judiciary sending a message, and is the public receiving that message, or is there progress in your opinion?
Well, I think we should focus our conversation on something called judicial discretion. That is where the rift is coming from. It is hard on either way. The public believes or thinks that the judiciary is exercising too much discretion, the judicial officers, to be specific. While, when you look at it from the angle of the judiciary, this is what is left for them now. Judicial discretion, especially the doctrine of contempt of court. This is the only platform where the judiciary's authority can be seen. For example, when you look at other organs of state and all that, judiciary, it has almost nothing apart from contempt. Well, that's what we are discussing, that when you look at our constitution, it's the contempt is only talked about, I think, once. That is under Article 28. Clause 12. So the balance is failing to be seen when it comes to judicial discretion. The public thinks that there is too much judicial discretion. For example, when you look at the examples you have given of Senior Counsel Semakade, when you look at Counsel Malema Birizi and the rest, you find it that even in a layman's understanding, a passerby who is not even a lawyer, they will just say, no, this is too much. The judicial officer acted maybe ultra-vires or whatever. But we cannot blame them because of judicial discretion. But then, we also need to protect our fraternity. That's why I say that it's a very tricky thing, that we need to strike a balance between the judiciary, the fraternity, and the public. Because, first and foremost, President John, the public won't understand anything about judicial discretion. They won't. You won't tell them that the judge has all the rights to maybe find honorable in contempt because of picking up a phone call in court. They don't know these things.
Perhaps what they understand is that the judiciary, whereas they have that discretion, but they must exercise it judiciously.
Yes. Let me give an example of Dr. Spire's matter. I'm going to be very, very realistic here, and I will say my opinion. In my opinion, I think the land judge was right in his decision concerning Dr. Spire's case, because he was very, very keen, and he explained his in my observation, the judge had to balance either to protect the sanctity of the judiciary or to please, I would say, the public. You get. And also, when you look at the respondents in their reply, they were very clear that let this gentleman pay the fine. If he succeeds on appeal, his money is going to be refunded. So it was a very fair thing. But because of what I told you, the balance between the public and judicial discretion, now that's why you see that the population is now looking at the judiciary as people who have done something very, very wrong. But in reality, it's protecting the judiciary.
Thank you very much. That was after that order, Mr. Mark. It comes in the attempt of Spire to stay execution orders. But let's look at why this was issued. You had earlier hinted at the fact that there was an injunction against him posting, about KI. But is contempt supposed to be granted in such circumstances? What remains of freedom of speech? And this also goes to the contempt in regard to Isaac Semakade. It came from his posts, his remarks on judicial officers, judiciary, and all that. Should contempt muzzle the people? What is the extent of contempt of court? if we leave it, because yes, I hear that there is judicial discretion and all that, but if we leave it open, isn't it bound to, to be so wide a net that it can catch everybody?
Thank you, Vianny. When we are talking about the concept of contempt of court, we are simply looking at the dictatorial arm of the judiciary. The power given to them, bearing in mind that this is an ancient doctrine based on the institution of kingdomship. Now, the judges are the kings in the courts. They are exercising their powers unlimited, what they are calling judicial discretion. Though they must all know that judicial discretion must be exercised judiciously. That is why I was asking, should we say all the people in the public are fools to come and contribute money for Spire, who is in violation of a court order? That is sending a message that even the public has distanced itself from the actions taken by the judiciary. When you go to the crux of the matter, he simply commented on the fact that when they transferred the child from the school, the money was not refunded. Several opinions came from members of the public. We had students complaining about missing marks. We had very many other complaints coming in. Now, like in the spirit of building an institution, of interesting people in the institution should have reacted on improving on the honest feedback coming from the public, but not going on the defensive to block people from speaking about your bad side. In other words, what we are seeing today simply implies that if any person came up tomorrow to castigate you, Vianny, if you know someone in the judiciary, you run to court to protect you against people telling you the honest information about you, because these are simply facts. Before we say that Spire was in contempt of a court order, the question would be, does Spire have a right to speak about the affairs of the country?
Obed seems to be having a point in that regard.
You say I want to disagree with my brother, honorary. To begin with, people who have been who were in court, the parties in court included Mr. Spire, not the entire public. Therefore, the injunction that was issued against who? Spire, in his personal capacity. Therefore, you can't say that people, the general public, or the people who are helping him to contribute on the fine, have distanced themselves from the decision of the judiciary. Yet, this, because it is not the public that was in the court with the institution, but it was only one person. That was Spire, and the injunction was issued as even then. The sub-judicial rule would also catch up with him. The matter is received before court. Why would you go on the press? Why would you go in public and start commenting on a matter which is still on a court going? Two, when you look at
the sub-judicial rule apply to the laymen other than lawyers, including Spire.
Well, it applies to everyone, because no matter that is still before court, you have no right to speak about it, because you don't know what is going to be the verdict of the court. So you have no right of talking about a matter which is before
on that point, let me first bring him feedback from Sharifu Mwanda. Obed, there is feedback from Sharifu Mwanda which says Aaron Chiza called the underlying order a gag order dressed in legal robes, framing it as an attack on freedom of expression and on the right of ordinary Ugandans to hold powerful institutions accountable. Well, on that point, if there was a child taken to Kayu and fees could not be transferred, was it improper to comment on that issue? To say my niece, whatever, has money and has not been transferred, paid money, but has somehow disappeared in the system.
It's like you are driving me to speak, to talk about the core reason as to why he was dragged to court. Yet that decision has not been taken.
Now, Obed, if you may afford me an opportunity.
Just a minute. Okay. Why I'm saying you're dragging me to speak about the reason why he was taken to court, whether he was expressing his grievance as to the action of the institution, or whether he was just speaking as an ordinary Ugandan, so that the public can also understand that there is some justice in the institution. That was part of him, which he has to explain in court with his lawyers. Yeah, but now what is what is on the ground is on the issue of having been found in contempt of the court order, and even then, if when the matter was in court was his, and then a court order, an injunction was issued against him, did he have the right of again going back to comment on the same matter on Twitter?
You know, Vianny, the challenge we are having is the circumstances or the facts of the matter before court. If this is left to continue, it means tomorrow we are going to have another judgment stopping you from commenting on the affairs in the country. Because we are looking at an institution of learning having over 2,000 people. Now, if you come to issue a restraining order about someone talking about it, does it mean if it caught fire in the night, we are stopped from commenting about what transpired?
Freedom of speech, and everyone has that freedom.
Yes, now, can we stop people from commenting on an institution which serves the public?
I would love to...
No, let me give an example. If we had a suit of Uganda versus Mark, does it mean that now in court they should issue an order against Mark from speaking about the affairs of Uganda because there is a matter of Uganda versus Mark? And those are the facts here. It is an institution with factors or issues that affect almost a big section of the public, which cannot refrain from talking about them.
You see, you have your rights as a Ugandan, but you must exercise your rights without violating other people's rights.
Jack, let's come in from there. You have a right, but you're not supposed to use your rights in violation of other people's rights. But I want you to come in on the issue of freedom of speech and being able to comment on national matters. Do you think there is a threat to that freedom?
Well, we need to understand, I was listening to my brothers here having divergent views about freedom of speech. We need to understand that a freedom of speech is a derogable right. This is a right that can be taken away from you. Having the right to speak.
And the test has been confirmed in Charles Onyango and Andrew Mwenda.
Exactly.
That there must be what is demonstrably justifiable in a free and democratic society.
Exactly.
Now, when you look at what Honorable was saying here about a gentleman commenting about an institution that was about 2,000 students and all that, we respect that fact. But the matter in question here is not about speaking about an institution. We have a matter of law here that we need to address.
Exactly.
When you look at the racial discipline of that judgment, the land judge expressly talked about Order 43, Rule 4 of the Civil Procedure Rules. And he was very, very clear. He said he's not handling the issue of spy appealing. No, because that is his right.
Right.
He has the right to speak, he has the right to appeal and all that. But we are addressing specifically the issue of contempt, and which is specifically safeguarding the sanctity of the judiciary. Not an individual spy, not an institution tie you. So, people have the freedom to speak. They can speak. We can comment about almost everything. But if we are commenting about these things, we have to know that institutions, government entities, individuals, and mention them, they also have a right. We need to understand that. We need to put that into consideration. Not this thing of claiming they have a right to speak when you're infringing on other people's rights.
Exactly.
Care as an institution has rights. They are procedures. where a child or a student, if not handled well, there are steps which they can go through. So let us not individualize this thing. Let us look at it objectively.
Exactly.
So when you're talking about freedom of speech, let us also look at the affected parties here. It's not about me speaking all the time. How about the person who's receiving this? You get my point.
Exactly.
I get your point, and that's why I'm. Yes, you.
And then to add on my colleague's submission, the beauty part of contempt of court is that you are not going to be held, or you're not going to be judged without being accorded a chance. Actually, they give you a right. You have a right to fair hearing. They give you a chance to be heard. You have to be represented. So, in respect of this whole matter, and my brother, I want you to understand that this is not an attack to Mr. Spire as an individual, but look at it objectively. You have done an act which is infringing on somebody's rights. The person has dragged you to court. Court has issued an order stopping you and refraining you from doing further acts that are infringing on the right of this very person. You have gone ahead to do the same acts. First of all, it means you yourself don't have respect of the very court that has issued the court order. Two, it's like you think what you did was right, but then you're being dragged to court for having done the right thing, yet the person who has dragged you to court says what you did was the wrong thing. And then a court order has been issued against you. Then you have deliberately violated the same.
I think there is a misconception here, Vianny.
I want to come to you.
Let me first clarify on that. There is a misconception. No court has come out to say that Spire violated any person's right. So it is not proper for us to mislead the public by saying that court stopped you from violating another person's right. It means now court has already pronounced its judgment against Spire, which is not the case. There is no court order saying that Spire violated any rights of KIU. I entirely agree that the court orders are supposed to be respected.
Exactly.
But the moral question is, why do you think the public has this time come out in support of Spire? It means the public does not agree. Spire is not the first person to be held in contempt of court.
So
why has the public come out before?
Does not agree that in the first place the contempt order was supposed to be passed.
Yes. And I'm one of those that do not agree.
Councillor John, we need to first of all understand the public has never agreed on any contempt.
Exactly.
No.
We have seen the
We have had, no. I gave you the example of the case of Kakbaji and Erasmus Sanjuranabo. It went on it was on media, it was everywhere. Who came out to say it was wrong? Even people in the public understand. But what is the moral concept in the decision of court?
Thank you very much. And I want to come to you again. If you're dissatisfied with the contempt of court order, what next? What should someone do? Because if I gather very well, someone said the only provision that speaks about contempt of court is in the Constitution, and is just mentioned once.
The criminal contempt.
So what happens if someone has been found in contempt of court? I saw some people saying online practice is hard. We are trying to practice law online, saying you do this, and you do that.
Yes.
So what is the remedy?
There are two.
I want to be honest. There is a court order that has come specifying what you should do, and in the alternative, another punishment. The remedy should have been appealing against the order. And when you appeal against the order, you must come and apply to stay execution of that order. Now, the contempt order issued against you. But the order that has been issued against you does not give you the time to exercise those rights, because it is making immediate orders that should be done in a time frame where you cannot exhaust the other remedies. Now that's a question, a take home to both of us here, that we need to define guidelines for contempt orders. If you're saying that I'm in contempt of court, the orders you're giving me should bear in mind the time within which I should lodge an appeal. Bearing in mind, affording me an opportunity to file an application for stop execution of that particular order. Because in the order they are saying, you either pay, or in the alternative, go and serve a sentence of 3 months. That implies, if I do not pay, I'm serving the sentence of the 3 months. But remember, I have time within which to file an appeal. I have time to file an application for stay of execution. And now the question is, while I file the appeal and an application for stay of execution, within what time can this application be fixed? Now, does the application for stay of execution stop the execution from going on? The answer is no. Now, in such a situation, we are capped that we do not have a legal framework to regulate the legal discretion of finding people in contempt of court orders.
Obed, are you happy with the legal framework in far as the contempt of court is concerned?
So when I react to his very submission, it seems he seems to be suggesting that the law governing contempt should also avail an opportunity to the people who have been found guilty for contempt of court, an opportunity or time within which somebody can appeal, and then also apply for a stay of execution. So he's trying to say that the law somehow is bad because it does not have an opportunity for a person to appeal against the what?
No, maybe you didn't get me proper. I'm saying we do not have an elaborate law. There is no statute that's giving guidelines on contempt or how contempt should be handled. It is simply judges exercising still their discretion, setting for us limits on where we should go and where we should not.
So do you agree?
Exactly. Somehow I can agree with him. Yeah, I do. But then that does not mean that justice will not be served. Justice must be served. Because the reason why we are even discussing about issue of contempt is that there is a matter and the court order has been issued and the court order has been violated. It can either be issued before or after the final judgment. So either the order before or the order after, if it has been violated, the same thing will happen. So but why would we look at violation rather than putting in force the court order or doing what the court has ordered?
Thank you. Jack, you agree the legal framework, is it sufficient in your opinion? If today you were found in contempt of these proceedings, would you be comfortable with the legal framework?
I'm not comfortable with the legal framework regarding contempt. Number one, I would suggest that we have some legislation concerning basically criminal contempt. Because for civil contempt, I would say that it's settled block. The guidelines are very understandable. But then for criminal contempt, we can have legislation about that. I mean, we are lawyers. We have very many things to write about. We can have researchers do research about this. And another thing that we can handle about criminal contempt is the issue of discretion. Because what if Honorable here becomes a judicial officer next day, he sleeps and wakes up on the wrong side of the bed. He tells me, I don't like the height of this gentleman. I would also hold you in contempt. So I think we need to handle two issues. Number one, we need legislation concerning criminal contempt. And we need to have a honest discussion about judicial discretion.
Thank you. Give me your final remarks as well, Jack, so that we come to a conclusion in 1 minute.
Thank you very much, President, for this opportunity. I thank your viewers. Just want to make a little shout out, very unique, to my girlfriend Flavia. I love you so much. They say lawyers don't have love.
You found love finally.
Yes, I found love.
We need to celebrate that on the checkpoint.
Okay. You found
interesting. Now Flavia is a lucky one. Over to you, Obed.
Yes. Thank you very much. Briefly, I want to appeal to the general public that we've been handling issues to do with the contempt of court. The civil contempt may be very clear because out of practice, and it is something that is black and white, where you see a court order has been issued and you have violated it, you will still be dragged to court for contempt of court, and the consequences will follow. When it comes to criminal contempt, this is what mostly catches people pants down, because it is not written anywhere. Just like the other laws that are in force, sometimes Ugandans don't know that there are laws. Only when they are caught up by the wrong side, that's when they know that we have laws. Actually, even lawyers, some lawyers get surprised when they get to look at an offense, I mean, the charges that have been put against them. People are like, but I didn't know this. When you go down to check in the laws, you find the offense is there prescribed and its punishment. So when it comes to contempt of court, some people don't know that even when you interfere with the court proceedings, people are quiet in court, they are listening to the proceedings, and then you come and shout and make noise. People don't know that even leaving phones in loud and they shout, that is also another contempt of court. People don't know that even when you go out and start threatening witnesses, that is already in contempt of court. So people get to know that this is a contempt of court after they have been caught pants down. Now, to avoid that, let us learn to respect the court and its orders. Let us maintain the sanctity of the court, such that when you come to court, honor the people who are in the court, I mean the judicial officers, and respect all the court rules.
Thank you.
Then lastly, as we go home, I want to send a message to the fellow Ugandans. Let us all follow the laws and be law-abiding citizens for God and my country.
Thank you very much. Over to you, Mark.
Yes, I want to thank you all viewers that have been watching this show. And the take home is, once there is a court order, the only obligation that you have is to comply or obey it. It is just a dictatorial regime under the legal perspective. That is now the dictatorship in the law. Your only role is to comply with the order. But still, we appeal to the judiciary because you are members of the public. The orders that you give, the public should be in position to resonate with those orders. Otherwise, soon, I know Obed may not want to hear it. We even have the most contempt that once you speak,
that is yours.
The following day, you have no right to be heard. He exercised the discretion to throw you where he wants.
You know where you
more than my country.
Thank you very much. That's a new contempt. We will find out how it works. But thank you very much for having listened to this checkpoint this evening. It has come to you on U24 Television, the National Youth Development and Educational Channel. This evening we are discussing contempt of court, behind the power of court in the judicial proceedings. And I had an able panel with me. I had Jack Kateeba Musoke, he's a lawyer. I had Obed Nankunda.